Good afternoon. We are pleased to have you join us today. This is the inaugural webinar for our rather newly minted industry group, FBT Tech. And we will be offering a series of webinars over the next, hopefully on an ongoing basis, but certainly this one we're excited to start off with, and the series is dedicated to sharing with you our legal knowledge in the tech space. So with that, we will begin. The topic for today is the anatomy of a HIPAA breach and what you can do to prepare. I'm Jane Shea, and my co-presenter is Chad Eckhardt. I work in the information security and data privacy group here at the firm. And Chad, why don't you introduce yourself?
Thanks, Jane. I'm Chad Eckhardt. I am a corporate attorney with a focus on healthcare, and HIPAA has obviously become a large part of that. Jane and I are both members of the FBT Tech community and provide our privacy expertise with respect to that group.
So just to give you a preview of the program over the next hour, we're going to talk initially about the origin and purpose of the breach notification rule. We'll give a little overview. Chad will give a little overview about HIPAA and its evolution to what we are dealing with today. Then we will look specifically at the anatomy of a HIPAA breach. We'll talk initially about the preparation that's appropriate in advance of a possible breach, and then we'll talk about the steps, the process, the procedures that should kick in during a breach, what you need to do about stopping the harm, mitigating loss, and taking corrective action, and notification, of course, and then following the breach, what are best practices, what are good steps in that regard. So with that, I will turn it over to Chad, who's going to talk about HIPAA overview.
Yeah. So HIPAA, as you guys know, has been around since 1996 with regulations that came out years after that. But what we're really focused on today is the anatomy of the breach. And one of the biggest aspects of the breach, and why it's so significant today and why we're talking about it, is because of the breach notification rule. And that rule originated in the HITECH Act that came out in February of 2009. The HITECH Act was a part of the American Recovery and Reinvestment Act of 2009. And as modeled like many other recovery acts, the government was trying to spark the economy and wanted to utilize opportunities to develop infrastructure within the country in order to provide jobs and strengthen the economy and give us a platform to move forward into a new age. So the HITECH Act was focused on that with respect to health information. One of the components of the HITECH Act was the incentive programs that the Centers for Medicare and Medicaid were providing. The most common was meaningful use. That was directly tied to healthcare providers' ability to use electronic health records in a meaningful way. So as the government was trying to promulgate the use of electronic health records, the concern was that that promulgated use and the more intense use is going to lead to inappropriate uses and lack of privacy and lack of security. And to balance that, the HITECH Act came up with the breach notification rule, which basically stated, and this was in section 13402 of the HITECH Act, that a healthcare provider or a business associate would need to notify the individual or the covered entity of a breach of that individual or covered entity's protected health information. What the government was trying to do was to make sure that individuals were aware of the potential risks and harm that could be associated with their disclosure of information that was inappropriate. But they wanted to balance that knowledge with the concern that if the standard is too low, then you end up with too many notifications and it watered down the significance of it, therefore not really giving individuals the proper, guidance with respect to actions they should take to protect themselves. So there was a balance that was needed to be struck. The interim final rule in August of 2009 struck that balance initially in a way that providers were pretty pleased with. The balance was struck that a breach was not, impermissible use was not considered to be a breach if it did not pose a significant risk of harm, whether financial or reputational or otherwise, to the individual whose PHI was subject of that breach. So the bar was if there's significant risk of harm to the individual because of the inappropriate use. That's a fairly high standard. Well, as you can see, that interim final rule sat there for about 4 years until the department decided to release the omnibus final rule in January of 2013, which was effective later that year in September. And those final regulations took into account a number of different things, including the breach notification rule. And one of the real significance with respect to the breach notification changes that the omnibus rule had was with respect to that standard. As you guys likely have heard, that the final rule no longer uses this harm standard to define a breach that needs to be provided notification of. Instead, what they've done is they've said that a breach is an impermissible use that compromises the security or privacy of the PHI, of the protected health information. So two things happened there. The first thing is that you no longer have a significant risk of harm. So it's not a high risk of harm. Instead, you've got the word compromises, which sort of means leading into danger. But it's not very defined. Significant has some sort of level of understanding in the community that it needs to be kind of major. It needs to be important. But to compromise, to lead into danger, that doesn't really give you a whole lot of understanding of a fine line of how much danger or how exposed does this need to be. And then the second thing is the focus isn't on the individual. Keep in mind the interim final rule was financial or reputational risk of harm to the individual. Now the focus is on compromising the security or privacy of the PHI. So it's not whether that compromised PHI leads to harm for the individual, it's just that the PHI is exposed to more danger. And so those are two very significant changes that have come out with respect to the omnibus final omnibus rule that have led us to having conversations about this with the clients from the beginning of breaches that have occurred in 2013 up to today.
Okay, so with that background and foundation, I'd like to spend a few minutes talking about the preparation involved for and planning for a breach. Everyone, I think, is aware of the fact that it's certainly a best practice, if not a regulatory requirement, to have a written information security program, to have a breach response plan as part of that program. I think there are many different ways of going about this, and some take a high-level approach and say we'll just put in the bare minimum. Others have taken a more substantive approach to it. There are certain components, no matter what your approach, that should be focused on. The first of them is the importance of describing what an incident is. So an incident may not be a breach, but an incident should be something that has the potential for a breach, and that is something that should be reported to a central hotline or individual who can then evaluate what the risk to the organization is. So describing what an incident is in detail is an important component of a well-crafted breach response plan. It should certainly include loss of a laptop. It should include clicking on a link that causes your computer to malfunction or act strangely. It should include a lost paper file containing information, that PHI. That may not rise to the level of a reportable breach, none of them may, but they deserve further inquiry and investigation. Another thing that is an important component is the internal incident response team composition. So this should be a team that it will vary, the members of that team will vary from organization to organization, but it should certainly be more than the Director of Information Security. It should be, it should also include legal counsel, the General Counsel's office. It should include the Director of Physical Security for the entire organization. It should include a number of different persons who have some significant role within the organization, and identifying those persons both by title and by name is an important component. The plan should, the planning process should include lining up external support as well, and those persons would include outside counsel, forensics experts, breach response firms that will create the notifications themselves and dispense with having to handle all of that in-house should the need arise. Those individuals should be identified in advance, interviewed, and considered perhaps with RFPs, so that you have a team ready to hit the ground running should the need arise. You're not scrambling to identify who you're going to call for additional assistance. Performing and updating your security risk analysis and risk management should be an additional aspect of creating this breach response plan. You've hopefully done your initial risk analysis. This is an ongoing process, hopefully, that is reevaluated and readdressed as changes in the organization take place or processes are changed. The security risk analysis should not call for you to categorize the incident on day one as a breach or as a non-notifiable breach. There should be a methodical process for making that evaluation, and the risk management team should be involved in the process for categorization. Additionally, establishing internal reporting requirements. So we talked about what the trigger is, identifying it as an incident. What are the decision points along the way? So establishing a central reporting place, such as a hotline or an email address, is an important first step. But then what happens after that? What you're calling in your internal response team, but identifying within that a timeline with decision points about who gets contacted, at what point, and what triggers contacting outside counsel, etc. should all be a part of that, that process. The investigation process and the process for analyzing whether a breach actually occurred. This should not, within the plan, written plan itself, shouldn't be overly prescriptive, because you don't want to get bogged down with written steps that aren't relevant or have no, don't bear fruit for a particular incident. But at least identifying who's involved and what servers are to be looked at, what categories of data are involved, identifying that. Those are the sort of things that should be addressed in the plan. And then, of course, establishing a notification process is an important part of the plan as well. Covered entities should have a systematic approach for that's documented in your policies and procedures with respect to who potentially could be entitled to notification. And similarly, business associates should have a systematic approach for identifying which of their customers that are covered entities that need to be notified as well, with contact information, so that nobody's scrambling to, page through a contract to try and find where notification has to be provided.
Jane, can I jump in real quick?
Absolutely.
I wanted to go back to the point about the investigation process, and Jane indicated something that's very, very important when you're developing this. She indicated that you don't want to be overly prescriptive. And you've already identified a privacy officer and a security officer, both of which who have good capabilities of understanding HIPAA, understanding the breach notification process, and you want to rely on them to be able to make decisions when breaches occur. So like Jane's indicating, if you have a very prescriptive investigation process, you're going to need to consider that with how broad you're defining an incident that gets reported to the incident response team. Because a lot of these incidences can be dealt with from the privacy officer, security officer solely, and you don't want to make the process so cumbersome that you're convening the incident response team for reasons that may be unnecessary. So I think it's really important for you to balance in your plan those two things: the scope of the incident that gets reported to the privacy officer and security officers versus which types of incidences go to the security response team.
Thanks, Chad. Good, very good points. With respect to the investigation as well, you're faced with, as Chad mentioned earlier, in many cases, we're not looking at the harm anymore to the individual data owners. We're looking at the presumption that if PII was compromised, it's a breach, and then there are 4 factors that go into the analysis of whether there is a breach. And do you want to talk about that now?
Yeah, those factors get in. They're the factors that fall under the breach notifications risk assessment, and it really looks at the factors that you need to consider if you're going to determine that there's a low probability that the PHI has been compromised. And so you need to be aware and include that in the investigation step as something to consider and to conduct that risk analysis in order to rebut the presumption that any incident is a breach. But that's going to be an assessment that gets made during the breach. So we want to make sure that everybody's aware of that at this point to put that into your incident response plan up front, but we'll dive into it a little bit deeper when we're looking really at what occurs during the breach.
Okay, good. Another point I wanted to mention, going back to the internal reporting requirements, it's a good idea. I had mentioned a hotline. It's a good idea to have a hotline or have a process for perhaps text messages and a phone chain, because if your system's been compromised, you may not be able to rely upon email as a functioning system within the organization. So having an alternative notification process, such as a hotline and using telephone numbers, is a good idea. So then moving to the approaches for mitigation, by this I mean giving some evaluation to third-party services such as identity theft protection services. That's become sort of an industry norm to offer identity theft protection services to victims of identity theft. And so evaluating what services are out there and who the preferred providers might be is another good idea to include in your plan. Also coordinating with business associates. You'll, as I said previously, if you're a covered entity, you'll have wanted to identify all of your business associates, and then similarly for business associates, identifying all of your covered entities. And you'll want to have a synopsis of each of the contracts to have a quick reference with respect to what types of incidents are in fact reportable to your covered entities if you're a business associate. There are a lot of different levels of notification obligation that can be negotiated in a business associate agreement. And so you'll want to have a handle on what those different levels of reporting obligation. If there's, in some cases, if it's a mere suspicion of a breach, it's necessary to report it to your covered entity. In other cases, it could be a much higher standard or higher threshold where it is not reportable to the covered entity unless it's a known breach. So having a handle on what those, if you don't have the luxury of a uniform contract provision, having a handle on what those are in advance is very helpful as well. And then finally, the plan should include a post-mortem requirement. Too often I think that when a breach is suffered, with all of the headache and time that goes into responding to the breach and the notification and repairing and plugging the breach, when that's finally over, there's a tendency to move on without taking the time to review what happened, why it happened, and to learn from it and address whether there are changes that are necessary. So that should be a component as well. So with that, we'll move to the next topic.
We're going to now dive into what you're going to be dealing with and what it's going to look like when you are in the midst of a breach. An incident's been reported, and now you're implementing that plan that Jane has just described. And so the strength of that plan gets tested when you have your first few incidences. And your plan should evolve. You'll find where you had some weaknesses in that plan, despite the advice that we're giving today and other advice that's out there. And it should evolve with your organization. But the better that plan is, the better developed that plan is, the easier you're going to have dealing with the crisis. And from my experience, HIPAA incidences are really broken into the large incidences that have, over the impact of involving over 500 individuals PHI versus the small ones. And once an organization has a large breach, there's a lot of attention that gets put to it. The plan gets used, but if it hasn't been a well thought out plan and a well developed plan, it may not be the plan that gets followed as we deal with a bigger breach. So it's really important to try and develop that plan in light of the fact that you're likely going to have a large breach and that your organization is comfortable following that plan. Because if they're not, from the top down, then it's not really worth having a plan. So please pay a lot of attention to that time, because that's going to be what's driving you through this crisis and dealing with it. And so the first thing is you have to stop the harm. Okay, we've identified that there's an inappropriate use, there's inappropriate access to our systems. We need to stop that. And then we're going to need to mitigate the harm. And I want to talk a little bit about mitigation in a way slightly different than what Jane was talking about with the harm to the individual, because our standard is now, trying to mitigate the harm to the PHI that's now been put in danger. So we have to stop the harm and mitigate the compromised PHI, and that requires gathering all the facts. So you're going to get an incident, but you're not going to know all the facts, and so we need to have some processes built into our plan in order to gather all the facts. Who on the IT side is going to be able to get into the system and really look at what's being exposed here? Questions about the date that the breach occurred, when was it discovered, approximately how many individuals might be involved, the location of the breach, if it's a lost laptop versus if it's a hacking situation. You need to deal with those types of things. Identifying the type of PHI that's involved, if there's any financial information that's involved, personal information, clinical information. You need to really start trying to gather all of that and getting a description of what's really happened here. And you might find that the breach has different categories of individuals, some that are only affected because of financial information, others that are affected because of financial and clinical information. But you want to gather all of those facts so that you can stop the harm as quickly as possible. You might have to convene the incident response team in order to do this. You look at your plan, and as we've already discussed, you're going to have thresholds when the incident response team needs to be convened. And when you do that, then the control, likely under your plan, is given to the incident response team in order to make the decisions, as opposed to just the privacy and security officer, who likely are guiding that team. But you need to get them involved so that you're making sure that you're following your processes. That's something that the Office for Civil Rights, who enforces HIPAA, is going to want to make sure that you're doing. There's no sense in having this institutional policy and procedure that's in compliance with HIPAA if you're not following it. So if you need to convene your incident response team under your plan, you need to convene them under the incident. And sometimes that slows the process down, which is very difficult in a time-sensitive situation like this. Then we need to identify what proactive actions or protective actions we can take in order to mitigate the compromised nature of the PHI. We want to mitigate the danger that the PHI has been put into. We're not really talking so much about the harm to the individual right now as a mitigation, but we're really looking at trying to mitigate the compromised fact that the PHI is in danger. In order to do some of that, and after that's been done, we still need to investigate further on all of the breaches that we've worked with. The facts come in slowly, and you want to make sure that you've investigated to the fullest extent possible. And really, the reason that you want to do that is this third bullet point here about the documentation. And if you're investigating an incident, it may or may not be a breach. That's what we're talking about here, is verifying if a breach has occurred. But if it is not a breach, it's your burden to show OCR, the Office for Civil Rights, that this incident was not a breach. And they're only going to be looking at the documentation that you're required to keep in order to make that determination. So it's your burden to document that, and having a full understanding of the facts, demonstrating your investigation process, that you looked at so many different avenues, whether or not they yielded any factual results, is important to let OCR know that you did everything you could to understand that potential incident and try and resolve it, whether or not a breach occurred. But in the event that a breach does not occur under your analysis, it's your burden to prove that, because you won't be sending out notifications. So the investigation here, the first bullet point, kind of working backwards, is to conduct the risk assessment. And conducting the risk assessment is, what we're really trying to do here is look at these factors that I mentioned earlier to see whether or not we can get over the presumption that a breach has occurred. And so under the Omnibus Final Rule, an incident is presumed to be a breach unless you can perform a risk assessment to demonstrate that there's a low probability that the PHI has been compromised. That standard gives a low probability that the PHI has been compromised. Again, there's no factoring into the harm to the individual. We're looking solely at the compromised nature of the PHI. What danger has this incident exposed the protected health information that we have to? In order to make this determination, you have to consider the following factors at least. The nature and extent of the PHI involved, the type of identifiers, the likelihood of re-identification if there's any de-identified PHI that's involved there. This gets right back to the first point we're talking about, of gathering all the facts, investigating as fully as you possibly can, because you need to understand the nature and extent of the PHI that's involved, because that's the PHI that's being compromised. So we need to know how sensitive that is. We need to also take into consideration the unauthorized person who's used the PHI or has had the access to that. That unauthorized person can look very different in a situation where you've got a misdirected fax versus a stolen laptop versus a IT hack from an international community. So you need to really look at those and see who is it that's received the information, because they're the ones who have the real capacity to compromise the PHI. So that's a very important fact, and in breaches that I've worked with, it's been another individual at the business who is covered by the policies and procedures, and this doesn't really present much of a danger here to an entity that was being investigated by the FBI. So that entity obviously posed quite a bit of danger. So there's a broad range, and we're trying to just identify the information in order to use that to determine whether there's a low probability that the PHI has been compromised. Other things that you can do is determine, and you need to look at whether the PHI has been actually viewed or acquired. Your IT team can help you a lot there to see what information's been viewed through their systems. This obviously takes into account whether you've stopped the harm. If you haven't, then there's this ongoing concern that is being viewed and acquired right now. The final thing is the extent to which the risk to the PHI has been mitigated. Again, mitigation to the risk to the PHI, not to the harm to the individual. So the fact that you're going to provide credit monitoring or fraud protection or these other measures that Jane's been talking about does not fit into the determination of whether there's a low probability that the PHI has been compromised, because we're not looking at the harm to the individual anymore. And again, just to reiterate, this information, when we look at these factors, that's going to be conducting the risk assessment to let us know whether or not a breach has occurred. And so we'll work through that to make sure that determination is proper under the breach notification rule, which takes into account some other factors. So it's not just this risk of harm under the the low probability that the PHI has been compromised under the breach notification rule, but you also have to make sure that it was unsecured PHI, that it's an impermissible use of the PHI under the privacy or security rule, and then this final determination here about the probability of compromised PHI. So there's a number of things to look at as you apply those facts to the law that's out there. And finally, you have to just really document this information, because again, it's your burden to prove whether or not a breach occurred. Let's assume that we identify that a breach has occurred. We need to take corrective action. We need to retrieve the PHI, to the extent possible. That's going to be one way to get it out of danger, to make sure that it's not currently being acquired, that it's not being viewed or used anymore. So measures should be taken to try and retrieve the PHI. If you're unsuccessful in retrieving the PHI, document your attempted efforts. OCR, when they come to investigate a breach, wants to see that you took corrective action. It's wants good results, but it's more important that you're doing the things that are within your control that are reasonable to try and take this corrective action. This may mean that you have to contact individuals who've been involved for mitigation purposes. On small breaches, especially the example of the wayward fax or email, reaching out to those individuals to get some notification or attestation from them that they've destroyed the PHI, that they've returned the PHI, is very valuable to put in your file to demonstrate your investigations. You're going to want to also consider revising your information systems. This gets into the idea of the risk analysis, and Jane's going to talk a little bit more about later, and has already mentioned. But the risk analysis is looking at the risks that your organization's infrastructure subjects its PHI to. And so if you've had a situation where you've compromised your PHI, it's imperative that you go back and look at your information systems to plug those holes, to close those gaps, and to document that in your risk analysis. It's another thing that OCR is going to want to see as you are organically developing a stronger, more robust security policy. You're going to want to develop protective measures to offer to the affected individuals. Think about this from an organizational standpoint and the reputation of the organization and the needs of the affected individuals. You might want to talk to your insurance carrier if you have cyber insurance, or others that are identified in the security incident response plan that James talked about as to what is the standard in your community, what's expected, what are the costs. Look to your business associate agreements to see whether or not you're obligated to provide credit monitoring or fraud protection or however you want to handle that. But you do want to start considering how you're going to deal with the individuals who are going to receive this notice about the breach. And finally, you contact your insurance provider, get them aware of this just in case there's a potential claim that you want coverage for. There's likely timelines that you need to notify them of that potential claim.
Okay, a few other just kind of additional comments to what Chad just talked about, some common mistakes or what not to do when you're in incident response mode. Don't deny that there's a problem. The inclination is to get the system running again and proceeding with evaluating what your contractual or legal obligations are without really understanding what happened. And failing to escalate the issue to a higher level where it may be a higher level is necessary to really evaluate what corrective steps need to be taken. A good metaphor for this is if you came home late at night and found that you had an intruder that had broken into your house and you locked the door, then fine, you know that no one else can come in, but you've addressed the symptom. The door is the symptom. It's not the attacker still may be in the house. And so, kind of plugging and getting the system up and running again without taking a deeper dive into what may have been the cause of the problem is a common mistake. Putting the fire out and waiting too long to call in help. Insufficient investigation. So you need to engage in a root cause analysis to understand the time and resources required to carry out the corrective action. So things to keep in mind. At this stage of the breach, you also want to be analyzing the legal implications of the breach on your firm. The breach response should be conducted at the direction of either internal or external counsel. And it may sound self-serving, but as a practical matter, retaining external counsel can provide you with attorney-client privilege for the entire investigation should you be faced with some sort of litigation down the road. Everything that you have learned and everything that you have turned up in your investigation may be exposed to discovery if you don't have that shield. Certainly your notification obligations, evaluating who you have to notify, what the time frame is under the HIPAA notification rules. Additionally, what state law notification obligations there might be. So some state notification laws define, include health-related information in their definition of information or data that has been compromised that might trigger state law notification requirements, which may be different than in terms of time frame, and it may also, the HIPAA notification rules may also include a requirement of reporting to state attorneys general or other state regulators. We've already talked about reviewing the contracts and policies, so to the extent that that information is at your fingertips as part of a well-crafted plan, it's going to make that part of the analysis easier. Reviewing your insurance coverage and notifying insurance carriers is certainly an important element that Chad already mentioned, and analyzing what sort of indemnification obligations you have under your BAA contract with your covered entities. Assessing the risk of litigation or some sort of HHS action, and then last but not least, determining whether any employees were victims of the breach, and whether, or conversely, if an employee's actions merit termination or some other sort of corrective or disciplinary action. So those are a list of some of the legal implications to think about.
I'd like to jump in on a couple of these before we go to the next slide here. And the first bullet ties in nicely with the last two bullets, dealing with the risk of litigation or regulatory action and employment action if there needs to be some sort of sanctions taken against individuals for violation of their HIPAA policies. Ties in very nicely with this idea of privilege and confidentiality. And as far as the risk of litigation, as many people know, HIPAA does not give a private right of action to the individuals who are harmed from the PHI or a breach or the compromise of PHI. However, plaintiffs' attorneys have been getting very clever at coming and trying to develop claims under state law actions that would allow plaintiffs to recover. And so it's in those types of situations where they say a provider's breached their fiduciary duty of confidentiality, and they use a negligence standard, and they look to HIPAA as the standard of care. They haven't been all that successful in doing so because courts have realized that this is really a HIPAA-type action, and Congress did not want to give individuals a private right of action there. However, some are getting some traction, getting some success in various districts in various states of this, and I think it's going to happen. So you got to be aware of that. And to the extent that your investigation could be privileged because it was conducted with outside counsel or inside counsel in a non-business capacity, that's going to be very valuable in the discovery of those litigations. The regulatory action, OCR is so far behind in their review of the big breaches, and we're seeing the settlements come out for breaches that occurred in 2012. They will get to them, but it takes a long time. So they're going to want to see what's been documented. You have an obligation to document the risk assessment that I talked about earlier, but what goes into that risk assessment, what goes into that file is something that counsel can help you with, and the things that don't get put in there are the things that can be protected from discovery, as Jane was saying. So these same sorts of concerns deal with if there's an employee action. Dealt with a number of these situations where we've had a breach and we found out that it was an inappropriate use or disclosure by an employee. A lot of times it is self-serving or personally motivated, unfortunately, and HIPAA and OCR require you to take action against individuals who violate your policies. If that becomes contentious, which it likely will, there's the possibility of inappropriate employment action or discrimination action that will follow. And again, those same concerns about discovery are important in those actions as well. So I want to reiterate those few things that Jane shared as they're very valuable when you're dealing with these situations. So as we talked with dealing with the breach, we've gone through, we've mitigated, we've stopped the harm, we've identified everything that's happened, and now we get to the point of notification. And this gets separated into two different categories. Notifications for a breach involving the PHI of 500 or more individuals. That's a big breach. That's going to take one notification route. The other one for smaller breaches that involve less than 500 individuals PHI takes a different route. But I'll come back and talk about these. But the timing is applicable to both of them. You have to provide the notification that's required without unreasonable delay, and in no event later than 60 days after the discovery of the breach. So this, without unreasonable delay, is very, very important. As you're doing your investigation, you're trying to mitigate the danger that the PHI has been exposed to. That's one of those factors in the risk assessment to determine whether there's a low probability that the PHI has been compromised. You can't hold your notifications off hoping that you're going to find that the PHI, the compromised PHI, can be mitigated to the point that you don't have a breach. So, covered entities and providers try to get a little clever with that, and the department is not allowing that. That's why we have this without unreasonable delay. If you need to delay because you're still gathering facts, that's a reasonable delay. If you need to delay because you're working with outside counsel to determine whether a breach has occurred, that's a reasonable delay. But you can't delay more than 60 days in any regard.
I should mention briefly, there's also the element of law enforcement requesting a delay and, sometimes a delay in notification. And so that's another thing that needs to be evaluated in that analysis.
Yeah, very good point. A law enforcement officer may come to you and tell you that you cannot disclose this because it's going to interfere with their investigation actions. Depending on how they tell you, whether it's in writing or orally, changes your timeline by which you can acquiesce to that request and hold off on the notification. But that would be a reasonable delay.
I think in the vast majority of the cases, at least from presentations I've heard from law enforcement, they rarely actually order you not to. They oftentimes request, put it in the form of a request. And so that lends an element of choice for you, and just another thing that, needs to be considered. What's the pros and the cons of holding off?
Yeah. And it's also interesting when you look at some of our clients that are publicly traded, and there's individuals sitting in the room who represent those clients. The SEC requires notification of material events, and sometimes a breach could be a material event. And there's some timelines there that need to be considered, as well as state law requirements, which may have a quicker timeline than HIPAA. We'll address that in a second. But so the timing is very important. It's something you want to look at. If the notification involves more than 500 individuals, the notification needs to be sent to those individuals, to the media, and to the Department of Health and Human Services within that 60-day time period. If the notification is with respect to a breach that involves less than 500 individuals, you need to notify those individuals, and you need to provide notification to HHS. However, the timing by which you provide the notification to HHS is different. And obviously here there's no media notice as well. So in the event that you're dealing with a breach of less than 500 individuals, the notification gets provided to HHS on an annual basis. And it's normally March 1st or 2nd, depending if there's a leap year in there. But you have to provide it through their website within 60 days of the end of the calendar year. And so privacy officers are large institutions that have a number of smaller instances to report. They end up blocking out a little bit of time at the end of February in order to get these put in. What they've noticed is, I think a year and a half ago, that reporting mechanism got changed a little bit, and HHS started asking a little bit more about the safeguards that were in place prior to the incident. So they're looking at how you're really utilizing that risk analysis to implement appropriate safeguards. And when they started asking for that information, providers got worried that that HHS would start looking and really coming to investigate the smaller breaches because of that information. If you report you don't have adequate safeguards, that's a red flag. You might get them in the door a little bit quicker. Whereas when they didn't ask that information, there was much of a less of concern. So that notification timeline is a little bit different. And then consider state law requirements. There's a number of states that have adopted breach notification rules. The notification pertains to a certain type of personal information, whether it's protected health information or more likely individual information, so PII. You want to look at those to see if you're required to make notifications and to whom there. Some of the states have a carve-out for anybody who's subject to HIPAA's notification requirements. Unfortunately, some of the states who had those carve-outs produced fairly early in the promulgation of these HIPAA rules. They only carved out those who are covered entities because those were the ones who had to make the notification prior to the HITECH Act. So there's some question with the what's the intent of that statute versus what's the real notification requirement there. So you can take a look at it and work with it. As Jane said, most of the time it's the notification to the state attorneys general, and that's important because HIPAA's enforcement rule allows the attorneys general to go ahead and bring an action against the individual, the providers, whereas it doesn't allow the individuals to bring that private right of action, like we said.
Okay, so the final component of our presentation is after the breach. What should you be doing? And I talked previously about the importance of your response plan, including this sort of post-mortem element. And it includes things like revisiting and revising your security analysis, your security risk analysis. That's not a once and done thing. That should be done on a regular basis, and particularly after a breach has occurred. Important to learn from the incident and figure out what processes need to be changed, systems updates, or whatever the case may be. Maybe it requires additional employee training, but the policies and procedures in most cases will require some element of change because, and I think for HHS purposes, that's something that they're going to want to see.
Definitely.
And I would venture to say in every case, there's human error is the fault that probably 90% of breaches can be blamed for. We hear about the hackers, and in many cases that is not the cause of many of the breaches. It's an employee clicking on a link, or downloading, opening an attachment, or losing a laptop. Those causes are the cause of the vast majority of breaches. So regular training cannot be emphasized enough as a best practice. Chad talked a lot about documenting compliance with the breach notification rule, and again, an important step to take. And then finally, learning from others' mistakes is another thing to bear in mind. You know, the risk management folks should be paying close attention to their fellow covered entities and fellow business associates that have endured these incidents, and you know, taking note of how mistakes that were made in those organizations can be prevented in our own organizations.
That's also a good source to find this information is OCR's breach notification listings, where these notifications that happen that are given to the department are listed. And so going through there and taking a look at that is very helpful. Looking at the settlements that OCR has, there's not a whole lot of them. So when they settle an investigation for some violations of HIPAA, it's really important to look at that, maybe read the settlement agreement and the corrective action plan that's put in place, so you can see what are the real triggers that are getting OCR involved in seeking settlements and really enforcing the civil monetary penalties that come along with this. Very valuable to your institution. Plus, if you're doing this, document that as training and education. You can circulate some of these settlements to your organization's team as an educational training a piece, and that's very important because that's a part of the HIPAA security requirements, is training individuals on this. So you can utilize it to satisfy a number of different concerns, but ultimately the goal of utilizing others' mistakes is to learn from them so that you don't have those breaches.
So that concludes our presentation. We have a couple of minutes if you have any questions. There is a comment box on your screen that you could submit questions. In the meantime, I'll make a pitch for our next topic in this FBT Tech webinar series. The webinar will take place sometime in January, mid-January. We'll certainly communicate that date to you when we have a firm date, and the topic will be privacy and other legal considerations in the use of drones. So hopefully that is something that is of interest to folks, and that you'll tune in for that.
Drones are of interest to my 11-year-old. He showed me his Christmas wish list, and there's a few $100 drone on there. So don't know if that's the subject of it, but there's a number of drones that may be out there by January.
I'd like to see the disclosures that and cautionary disclosures that come with that.
Well, give me a few $100, Jane. I can give you those.
Well, thank you for joining us today.